How do partnership agreements affect taxes for high-earning individuals? Imagine sharing a big pie with friends, but how you split it can change how much each person pays in taxes. That's what partnership agreements do for high-earning people in sports and entertainment. They set the rules for sharing income, losses, and taxes among partners. These agreements are key because they determine how profits flow to each person and how they report it to the government. Partnerships are considered pass-through entities, which means the partnership itself doesn't pay taxes. Instead, each partner reports their share of the income on their personal tax return. This setup helps avoid double taxation, which is common with corporations. For high earners, this can be a big advantage because they pay taxes based on their individual rates, which can go up to 37%. If they are active in the business, they also pay self-employment taxes, which cover Social Security and Medicare. These taxes are 15.3% of their income, and high earners might owe an extra 0.9% Medicare tax on income above certain thresholds. The partnership agreement can also give flexibility in how profits and losses are divided. This means high-earning partners can sometimes allocate more income to themselves than their ownership percentage, if it's done carefully and legally. This can help manage their tax bills, especially if they have other deductions or income sources. When partners contribute assets like intellectual property or endorsement contracts, the agreement specifies how these are valued and whether they trigger immediate taxes. Usually, contributions of assets do not cause taxes right away, which is helpful for athletes or entertainers who want to bring in valuable property without paying extra taxes immediately. Partnerships file an informational return called Form 1065 and give each partner a Schedule K-1. These forms show each person's share of income, deductions, and credits. High earners need to review these carefully to report everything correctly on their personal returns. The agreement also governs when and how profits are distributed, which can influence cash flow and tax planning. In industries like sports and entertainment, partnerships are common for joint ventures, endorsement deals, or agency relationships. The agreement must clearly spell out how profits are shared and who is responsible for taxes. Because these income sources can include royalties, appearance fees, and endorsement earnings, the tax rules can get complicated. A well-structured partnership agreement helps high-earning individuals manage their tax burden by allowing income to be allocated in ways that are both legal and beneficial. It also makes sure everyone follows IRS rules and avoids surprises at tax time. In short, partnership agreements shape how high-earning people in sports and entertainment are taxed by deciding how income flows to them, how profits are split, and how self-employment taxes are handled. Proper planning and clear agreements can lead to tax savings and smoother compliance, making sure these individuals keep more of their earnings while staying within the law.